The $250 million civil fraud trial against Donald Trump has become more contentious and high-stakes. The contentious exchange in court between Trump's lawyer, Chris Kise, and New York State Attorney Kevin Wallace emphasizes the seriousness of the legal matter. A number of people believe that Trump inflated his wealth in order to get better deals on insurance and loans. The evidence that Judge Arthur Engoron found points to Trump and his organization being involved in fraudulent operations. Wallace claims in court that Mr. Trump is guilty of fraud. This was a quick response to Kise's accusation that Trump had received special treatment from Deutsche Bank's private wealth group. While Kise argued that Trump's participation in this elite club gave him a financial advantage, Wallace disagreed and said that Trump had entered the group dishonestly. As the trial progressed, the complexity of the evidence and the extensive examination of Trump's financial dealings became clear. The goal of the financial statement manipulation trial against Trump and his business is to establish whether they lied to lenders and insurers about the value of their assets. The outcome of this trial affects the public's perception of Trump, his political career, and his financial prospects. As with Trump's broader legal challenges in other countries, this court dispute is symbolic. As the case progresses, the public is closely following it, waiting for further information and, of course, the verdict. The narrative about Trump's business ethics and practices will undoubtedly be shaped by the court's procedures. According to Mary Trump, the niece of former President Donald Trump, Judge Arthur Engoron's gigantic ego and lack of self-control could lead to significant issues in his partial gag order against Trump. There may be legal ramifications for this complex issue. Mary Trump said in Benzinger's piece that Trump could get more angry and uncooperative with the court as the trial progresses, particularly over the gag order that prevents him from criticizing court personnel. She claims that his violent responses to feelings of embarrassment or threat are the root cause of his behavior. There could be serious legal consequences if Trump does not comply with the gag order. Using contentious rhetoric in the ongoing civil fraud trial has landed him in hot water more than once. Because of his history of violent attacks on court personnel, he has accrued substantial fines. As the trial approaches its crucial stages and the court prepares to hear final arguments, everyone will closely watch Trump's reaction to the limitations imposed by the court. It is worrisome that, as Mary Trump pointed out, Trump's legal troubles may not put an end to, or perhaps amplify, his long history of defiance and hostile rhetoric. Her background in psychology and insightful observations inform her unique viewpoint on the former president's potential responses to the ongoing legal challenges. The massive lawsuits brought by the Attorney General of New York and the January 6 panel inspection have already put a significant burden on Trump. Mary Trump is worried that her uncle, who is already in a difficult legal and political position, may become even more aggressive as a result of his mounting legal problems. Never forget that I'm merely speculating here about Trump's personality and potential reaction to his legal situation. The upcoming trial and succeeding legal processes will undoubtedly influence Trump's future political and personal trajectory. The contentious disagreement between Donald Trump and Stephen C. Bear exemplifies the delicate balance between the rights to free expression and the responsibilities that come with holding public office. There is a long tradition of political commentary and satire that often involves severe criticism of notable personalities. C. Bear's use of the word fascist and his criticism of the media are in line with this. It is crucial for a strong democracy that comedians and commentators are able to criticize political leaders and their policies in this way. But as Trump's reaction demonstrates, politicians are extremely susceptible to criticism, especially when it is humorous or uses insulting language. Trump's reaction, which some have called a meltdown, illustrates both the media's responsibility to criticize powerful people and public leaders' goals of managing their image. Based on their different replies, it seems like the public and media professionals have different views on these types of debates. Although some perceive Seabear's comments as a vital and brave form of political critique, others believe they cross the line into personal insult and contempt. This episode highlights the need to acknowledge the power of words and labels in political discourse. The use of strong emotions and polarizing terms like fascist might exacerbate existing political divisions. The conversation also highlights how media personalities greatly impact how the public views and talks about political people. Given their power to influence public perception, it is important to seriously consider the vocabulary and labels used in political criticism. Trump's reaction to Stephen Seabear's Nazi allegations and mockery raises intriguing questions about the limits of political speech and comedy, as well as the greater ramifications of these public meetings in this very divided political atmosphere. The ongoing conversation brings to light the eternal battle for harmony between the right to free expression, the responsibility of the media, and the amount of criticism that public figures are prepared to endure. The role of humorous political discourse in debates. It is possible to assess and critique the actions of political figures using humorous commentary, like that of C. Bear. Critiques of political personalities that cross the line into non-traditional discourse usually elicit a strong response. The bad press often elicits a strong response from prominent politicians, including Trump. The bad press has a powerful influence on politicians, including Trump. The way he responded to C. Bear's comments proved this. Political figures and pundits, public opinion, and the public's reaction can become even more insidious if this sensitivity prompts public rebuttals or attacks by the media. In these interactions, public opinion is divided. Some argue that the media unfairly or too harshly criticizes politicians, while others contend that the media should hold politicians more accountable. This divide is often a reflection of the increasingly polarized political atmosphere. The impacts on the political climate are significant. These debates amplify already existing political divisions and conflicts, adding to the overall political climate. They can spark debates, energize followers, and change people's minds about politics. Considerations of morality. Because of this, we are confused about the proper ethical behavior of media critics of politicians. It stresses the importance of peaceful, fact-check discourse alongside free speech. Public figures like Trump are susceptible to the far-reaching impacts of such meetings with the press. They have the power to influence how the public views them, how much support they receive from politicians, and whether or not future political endeavors succeed. In conclusion, the chat between Trump and C. Bear, together with the subsequent reactions, showcase the complex interplay between media, politics, and public opinion in contemporary society. Polite and thoughtful political discourse is more vital than the media's right to criticize and examine political leadership. In the 2020 election case, federal judges rejected Trump's bid for immunity, meaning he remains in jail. Please stay tuned until the very end because this news will make your day. Please take a moment out of your day to subscribe to our updates by clicking the button below and turning on the notification bell. We'd greatly appreciate it. Any law or policy that President Trump signs into law might subject him to criminal charges. On Friday, an Australian judge rejected his motion to dismiss the charges brought against him by special counsel Jack Smith, who sought to have him convicted of unlawfully attempting to revise his 2020 election defeat. After reviewing the evidence, the U.S. District Judge Tanya Chutkan found that the president is not immune from criminal prosecution once they leave office. In the 2024 U.S. presidential election, Trump was the leading candidate for the Republican nomination to challenge Joe Biden, the Democratic nominee. He held this position from 2017 until 2021. Chutkan concluded by pointing out that there can only be one chief executive officer in the U.S. at any one moment and that the presidency does not offer perpetual protection from prosecution, despite any benefits enjoyed by the current president. Presidents can face criminal charges similar to those faced by ordinary citizens, according to Chutkan's decision, the first of its kind from an Australian court. For all presidents, current and past, none have faced criminal accusations like Trump. This is a major development. The judge also dismissed Trump's arguments that the charges violate his First Amendment right to free speech. According to Trump's legal team, Smith's case attempts to outlaw free speech and other basic political activities. Todd Blanche, who represents Trump, declined to comment on the verdict. A jury trial accusing Trump of conspiring to obstruct the counting of electoral votes and prevent legislative certification of Biden's victory will now proceed following Chutkan's ruling. In his denial of the allegations, Trump has claimed that the prosecution is trying to damage his presidential campaign. The trial is set to commence in March. If Trump chooses to appeal the decision, the trial could be postponed while the issue is reviewed by an appeals court and, eventually, by the Supreme Court. Multiple motions to dismiss the case are now pending in court, one of which is that the allegations leveled against Trump are unfounded. Trump is facing state criminal charges in Georgia and an indictment on 2 more counts in relation to his endeavors to overturn his 2020 loss, in addition to the case that Smith is pursuing. In all of the other cases, he has likewise entered not guilty pleas. Authorities have determined that the U.S. Justice Department's previous policy of refraining from prosecuting presidents while they are in office is now moot. The president's legal team has always maintained that Trump is above all charges relating to his official actions while in office. They have voiced concerns that Trump's political opponents may try to deter him from doing his duties by threatening him with criminal prosecution. The legal team representing Trump contended that the same constitutional safeguards enjoyed by presidents should extend to their criminal prosecution as well. Because it would put the President of the United States above the law, prosecutors claimed that Trump's position would be a violation of fundamental constitutional norms. Your thoughts and opinions are also welcome in the allocated space. Judges on the Federal Appeals Court who were appointed by Trump himself denied the ex-president's assertion of presidential immunity from civil actions pertaining to the January 6, 2021, demonstration at the U.S. Capitol, as presented by his legal team. Watch this video, and we'll explain everything in detail. However, before we go any further, I kindly ask that any new viewers to my channel subscribe and enable notifications so that they may stay up to date with all our current news. Judge Gregory Katz, an appointee of President Trump's, stated that the only matter before them is whether President Trump has shown an entitlement to official act immunity for his actions leading up to and on January 6, and the decision was made Friday by a three-judge panel of the Federal Appeals Court in Washington, D.C., in accordance with the claims made in the lawsuits. No, is our response, at least for the time being. This ruling continues a pattern of judicial appointments made by President Trump, who has ruled against him on multiple occasions. On Friday, December 1, Newsweek magazine reported that in July, Judge Rog Singal, appointed by Trump in 2019, dealt a blow to Trump by rejecting a $475 million defamation case against CNN. Because it was used on purpose, the judge decided that the word "big lie" did not constitute defamation. In December 2022, a different lawsuit involving Trump appointee Andrew Brasher, 2019, and Britt Grant, 2018, resulted in the overturning of the ruling that had previously barred the Justice Department from accessing papers discovered during the Mar-a-Lago raid. In their ruling, the justices criticized the hermeneutic theory, stating that the removal of official papers had no effect on the document's substance or customization. Judge Katz concurred with the recent decision, showcasing the intricate nature of death penalty cases. Despite the casual nature of speeches given at political rallies, he contended that, in exceptional circumstances, such speeches may not be subject to prosecution. Katz cited President George W. Bush as one of the people. Think about the first reaction that President Bush had to 1911's. According to Katz, the court's decision to define what constitutes informal campaign speech was deliberate. A presidential address dispensing with capital punishment is unnecessary. Despite the defeats, Katz has stressed that the court did not rule on the question of whether Trump spoke in his official or private capacity on January 6. The decision implies that the former president's legal struggle will go on, and it raises doubts regarding immunity and its potential protection by the First Amendment. Special counsel Jack Smith has until Monday to inform Trump and his lawyers of any wrongdoings or crimes that the DOJ believes Trump may have committed, which could be used in his prosecution for trying to reverse the 2020 presidential election results, according to former U.S. Attorney Joyce Vance. Because they weren't part of the indictment that Judge Tanya Chutkan heard, the criminal charges didn't get much attention. Judges, according to Vance's explanation on his Substack website about Section 404B, approve any new evidence and determine which pieces can be used in open court. Vance explained that prior criminal evidence can establish various elements, such as motive, opportunity, intent, preparation, plan, knowledge, identification, lack of error, or accident. He stated that Mr. Smith was certain that, given the case's trajectory, he would provide substantial proof to back up his assertions on the terrorist assault and ancillary occurrences. Mr. Trump is intent on showing that he is aware of voter fraud and deeply doubts that his policies will spare the nation from the type of anti-government rioting that occurred on January 6. He had earlier emphasized that, in essence, everything was perfectly okay. If Mr. Trump believes a 404B recommendation will be presented, he must inform Mr. Smith of the acceptable purpose and provide his reasoning. By some stroke of luck, this compels Smith, or, depending on your perspective, presents him with the chance to inform the world about his situation to a greater extent. Subscribing is also required. I would greatly appreciate your opinion on this matter. Much obliged for your time.